everyone, if we can resume the meeting, please. Firstly, before I come back to participation, check again. Is the microphone still working okay for those at the back of the room? Is that am I audible and understandable? Just a reminder that there's an attendance sheet hopefully circulating around the room, and please make sure to look it out and sign it and put your contact details on before you leave. It's important that we have everyone's contact details for issuing the note of this meeting. Can somebody wave it in the air just to show others where it is just now? Thank you very much. So the purpose of the break was to allow, to the extent that it's possible in that period, some discussion between those who might collaborate. So I think the simplest thing for me to do now would be to ask those people who do wish to take part in the inquiry on their own, i.e. not to collaborate, and for the inquiry and hearing sessions who wish to issue a statement, provide us with a statement of case, a recognition, perhaps documents if they want to lodge other documents, and to give evidence and then be cross-examined. Now, I'm going to go around the room and ask for people to tell me who they are if they want to do that. We will issue the note of the meeting in a week or so, and that will list all those names and all those people who have done so. But that will be a further point for you to clarify or confirm that we've got that right. So that if you change your mind or if you didn't speak out today, you can always, in response to the meeting note, you can confirm if and how you wish to participate. So, I mean, with the caveat about what I've said about the value of collaboration, can I just ask if you can let me know if you want to take part in the inquiry sessions, and then I'll just take some details from you. So, can I have a show of hands first of all, just to see who would like to participate on their own behalf? Okay, and we've heard from you already, but can you tell me this lady here? I think yeah, if you can. I have your name already, but I think don't I? But as wishing to participate in which of the sessions in the natural heritage and protected species?
Socioeconomic. No, I beg your pardon. As I understood our conversation during the break in the natural heritage session.
Okay, thank you. And others, please.
Sir, if it's helpful, I've spoken to a lady and a gentleman from the Botanical Society of Scotland, with whom I will make contact after the meeting. It seemed to me that they do have something of real value to add, which is supplementary to what my witnesses intend to say, and if I can persuade them to join this this group, then that would be, I don't know if it'll save us any time, but certainly it's one less name you have to write to. I'm also, one of the team has been approached by Mr. Batten, Mr. Peter Batten, who is known to me anyway from other inquiries, and I hope I'll be able to help him.
Would that lead to an additional witness or witnesses, do you think, from Coul, or would it just be that their views would be incorporated into the case?
I really can't say, because I'm not sufficiently versed in botanical matters to give you a valuable response to that. But by the time we get to statements of case, I'll know that.
Okay, thank you very much. So, sir. Sorry, I just didn't catch your second name, Sir Colin. So you may wish to participate in your own behalf in support of the development. And so that would be in the second set of inquiry sessions, which are about the socio-economic impact stroke benefits of the proposal, yeah? Okay, that's fine, Mr Taylor, thank you. I mean, we'll note that if you subsequently decide to collaborate in that wider coalition, then that's fine, and you can let us know in due course. But for the meantime, we'll note your name as a wishing to participate and support. Is there anyone else before I move on?
Just to report that a lady in the audience offered to do some scribbling on behalf of enjoyment of landscape.
I'm not sure what that means, but I note it. Okay, thank you very much. And we will try and accurately record all this in the note of the meeting, but we will, at that point, formally give people the chance to confirm that we've got it right, and they will wish to participate as we've set out in that note. So I think the note of the meeting had indicated we were looking at this a start at the week beginning the 25th of February, and we it seems from the witness lists and the discussions that reserving 4 weeks is going to be prudent for that. So that would be 4 consecutive weeks from the week beginning the 25th of February would be our proposal. Does that seem okay to the parties up at the front here?
Yes, thank you, sir. That would be possible for all of the witnesses, with 1 or 2 exceptions that can be taken care of through timing. The only suggestion I would make is, if not for every week, given the distance that many people will be travelling, certainly for the first week, that the first day of the inquiry would be on the Tuesday, not the Monday.
I mean, we had assumed Tuesday to Friday each week would just be the most sensible thing. Thank you. And there was a point about, I think, one of your witnesses, Mr. Ferguson. So we can as things emerge, we can hopefully programme matters to take account of that.
The consultant hydrologist who we've retained is not available after the first week, as she's committed to going abroad, I think, to work. So could I put in a plea for that evidence to be taken in that week, please?
And okay, and Mr. Ferguson, I mean, you can perhaps let us know, but what we noted is the first week certainly not clear about the weeks after that, but that's maybe something you can help clarify. You know.
I'm certain that the witness wouldn't be available on the week commencing the 4th of March, but we will double check the 2 weeks beyond that. If he is available, then I will report back.
Are there any other programming, scheduling things we need to be aware of at this stage? No.
I don't know if you'd be attracted at all by starting on Monday afternoons instead of Tuesday. That can be productive. I'm expecting a bit of a barrage from the other side of the room, but it's certainly been done. I do bear in mind that it's February and the weather's not likely to be very good, but...
Yeah, I mean, I suppose for our point at least, it's also just having some time out with the sessions to prepare for the week ahead, not simply to travel up. But I mean, we can keep that in mind as an option. But and I suppose Tuesday to Friday seemed preferable at this stage. So, well, I was going to go on and explain that. So, if we're assuming a start date of the 26th of February, then 10 a.m. till around 4:30 to 5 would be the time we'd expect to set with a break for lunch. We could always start in subsequent days a bit earlier if that suited the parties, and if that was going to help us in terms of making progress, we could bring forward with everyone's agreement start dates, start times, say to 9:30. So I'll talk about in a moment about the how we hear evidence and how we need to share evidence in advance of the sessions, share the written evidence. But I do want to talk for a moment about the venue for the hearing session. It needs to be large enough. There are several requirements or nice to haves, but it certainly needs to be large enough to accommodate what seems to be likely to be a high level of interest. It needs to be accessible for those taking part, and ideally it needs to be suitable for live webcasting. We visited the community hall at Embo this morning. We were kindly shown around. It's, in terms of the main hall and its space, it's about 40% the size that this hall is, based on me roughly pacing it out, which would take us really no further than the end of these tables here. So, whilst in every other respect it seems an ideal venue, we do have a concern that just might be too small to accommodate the level of interest. It's a great venue, it's got well of Wi-Fi, it's close to the site, but it appears to us likely to be too small. And I don't know if there's any views on that, but or whether there's agreement on that, but we've filled the room today certainly, and that won't be the case for every day of the inquiry, but it might be for some days. So, and we've had a chance to see what this hall is like, and it was cold, and we can't get the we haven't been able to upload it to date, upload live, but on balance, I think our feeling is probably that this is the most obviously suitable and closest suitable venue for the inquiry. But I just want to give people the chance to make any comments about that.
I'm disappointed that Ember Hall is not satisfactory. I was rubbing my hands in anticipation when the half days were clocking up. I understand your point about capacity. Have you considered the Free Church Hall in Dornoch, which has considerable capacity?
We tried to get access to that today, but I understand there's something happening all day. But I know where it is, and what I was hoping to do before we leave is just to pop our head in, if we can, and see what the space is like. I had a look on some Google images, and it looked much smaller than this hall, but I'm not sure you can tell me otherwise.
My approximation would be 2/3 the size of this hall.
Yeah, I mean, is there any other local experience of that perhaps as a suitable venue that we should look into further? It does have the advantage of being a bit closer. Thank you very much. With a four-wheel drive available if it's wet, yes.
Can I?
So in terms of the church hall, there's the church at the corner of Sutherland Street, and I can't remember what the street is, leaving Dornoch to the west. Is that the Free Church or is that the West Church?
The Free Church is in Church Street, just off the square, leading to the south east. The Church Hall. The West Church Hall is just below the War Memorial in Dornoch, and Sutherland Road is at that corner. It's a church hall rather than a church.
So and that was my apologies. When you said 2/3 the size, you were meaning the one in Church Street, not the one in the west. The other one, similar size or smaller, or? We'll try and, while we're here, at least have a look into these venues and investigate them more closely if we can. I mean, we also, in arranging this meeting, asked Council and other parties if they had views. So we had some options, but certainly this seemed to be the most suitable for us in arranging this meeting. Okay, so for those taking part or who may be taking part in the inquiry sessions, and I just want to go through briefly what that entails, both on the day and in advance, and hopefully we can agree some timetables, some dates for the prior exchange of the necessary documents and evidence. So during each witness's evidence in chief, at the inquiry session, they would be invited to read their precognition, which is their written statement of their evidence, and then that witness would then be subject to cross-examination by opposing parties, and following which there will be an opportunity for re-examination for those who are being led, certainly, by that witness's advocate or representative. And we do ask parties to cooperate with each other to avoid unnecessary or repetitive, is that the right word? Probably not. Cross-examination. So when all the evidence is complete, each participating party will be given the opportunity to make a closing statement. Closing statements will be heard in the reverse of the order in which the evidence is presented, which means that we'll hear the applicant's closing statement last. And closing statements by the main parties should be lodged in type form before they're read out of the inquiry, or with parties' agreement, we may decide that closing submissions could be exchanged in writing after the inquiry closes, but we can discuss that when we start. So the inquiry process, in terms of what we have to do before that, it's based on the principle of prior disclosure of evidence. And every party is required to disclose their case to the other parties so that they know the case they need to answer, and well in advance of the inquiry, in accordance with a strict timetable, so that there's no opportunity for ambushing and someone introducing a new point to the inquiry which the other participants haven't had the chance to consider and prepare for. So, based on the dates for the inquiry which we've agreed, I'll just run through our suggestion for the timetable for the exchange of evidence. So we would ask those parties taking part in the inquiry sessions to lodge their inquiry statements by the 5th of December 2018. Now we'll set all this out in the note of this meeting. But your inquiry statement on that date, that would set out the particulars of the case that each party proposes to make on the matters we've specified. the documents to be relied upon, and a list of anyone who's to speak at the inquiry session on their behalf, including the matters to be covered by each person and their relevant qualifications. I think I'll run through these suggested dates, and if people see an issue or a problem, then just stop me and we can discuss. But if we say inquiry statements by the 5th of December, by the same date, 5th of December, I think we will suggest the lodging of the further written submissions on the policy matters which we've already discussed, and we'll give thought to how the choreography of that is to work. But we would see that process starting on the 5th, or the initial written submissions on the 5th of December. Any documents to be referred to at the inquiry should be submitted at least 28 days before the start of the inquiry. So that would make that the 29th of January 2019. And each witness giving evidence at the inquiry would need to lodge their precognition at least 14 days before the start date. So that would be the 12th of February. Precognitions should be a maximum of 2,000 words. And witnesses should not attach as appendices to their precognitions documents which other parties have not seen. So these documents should be lodged in the normal way, in accordance to the timescale that I've just mentioned. The Council has already tabled its draft schedule of conditions, and we would ask the applicants and any other parties wishing to do so to lodge their alternative schedule of conditions or their comments on the Council's set of conditions again by the 29th of January. And that would then enable the applicants to produce an annotated version of the proposed conditions, highlighting any agreed changes or remaining areas of disagreement by the 12th of February 2019. We've discussed earlier the scope for agreed statements, and that might help us focus the evidence at the inquiry. So our feeling is that the 5th of December, which is an early date, might be the best time to try and have those submitted, in order that the subsequent material can be informed by that and can be narrowed down as a result of that. Does that sound early? Well, is that enough time to do the agreed statements, 5th of December?
So that accords with, in general terms, the draft that Mr Thompson had looked at, and certainly for the applicants, we're keen that the statement of agreed matters is moved forward with the inquiry statement, as I'm sure you are, so that you can see the scope of disagreement through that process.
Could I ask you, through you, if the applicants will kick off the draft agreed statement so that it is in circulation relatively quickly? Or do you want the Council to do that?
The applicants are content to do that, probably initially starting between the main parties, and then once there's been a first round with the main parties, extending to the other parties.
You better define what you mean by main parties then.
Essentially the applicants, the Highland Council and the SNH.
Well, it's in all our interest to have that agreed statement covering as great a scope as it can, and then we can focus on what's in dispute. So, so the applicant can kick that process off at least, aiming towards the 5th of December, and as you say, which is the same date we would have the inquiry statements as well. Yes, and I suppose just underline, we talked about agreed statements in relating to certain matters, but there may well be a much wider range of material that can be covered in that, and whether that's about policies which are applicable, any technical information, some of the evidence before us, the greater the scope there is to have agreement on some of these matters, then the greater we would be assisted.
Sir, just on that regard, I maybe wasn't following the exchange in detail, but certainly my clients, the Conservation Coalition, would like to be involved in discussion and agreed statements, albeit there would be certain matters that we wouldn't have any involvement in. But I think each of the parties has made clear the scope of their likely involvement in the inquiry, which would determine, depending on how agreed statements are flowing forward. But certainly the discussion we've had on policy, I think all of the parties on this side of the table have indicated that they've got things that they would want to say on policy. So any aspect of the agreed statement touching on policy is certainly something my clients would want to be involved in.
So there is, as I said, we'll settle this out in the note, but that covers the exchange of the key documents that we're normally looking for. There's one other thing that we need to mention. I think to help everyone prepare their cases, our feeling is we need the applicants and/or the council to provide an indexed link, indexed list, I should say, and to produce all of the extant application drawings and the associated documents and the extant environmental information. We have all the documentation from the council on the website. Because of the way it's numbered and numbered and named, and some of it includes superseded drawings, and some of it there are duplicates of certain things. So it's very difficult. It has been very difficult for us to interrogate what's still extant, what came in what order, what is an appendix to what, and what is an addendum to what. So I think it would be very helpful to have that crystallised, and my suggestion was the 29th of January. Now I know that's early, but in order that we're all working off the same agreed set of documents. Does that sound... Sorry, I beg your pardon, the 21st of November. Because I mean, the documentation is all, there might be the odd omission, but it's all there on our website. It's just that it's very hard for us to understand what's what and what relates to what, and whose comments are about what, if you understand me. So is that something that could be progressed by the council or in association with the
Just so that I understand correctly, the date in November that you're suggesting, is that just for the list itself rather than the physical documents?
Well, I was thinking the documents themselves, because they already exist. My concern is, if it's just the list, we'll still have a separate set of documents which are named differently and numbered differently, and I don't want to pick the wrong document up and not know that I've got the wrong document up. So I think it would be much easier for us to have the list and the documents, and you can really, and not just for us. I think the last thing we want to do is all turn up on the day and we've got if everyone's had looked at a different document or made some assumptions. In a normal appeal case, we necessarily get this information in a much more understandable form, but in a notified case like this, it comes in a different way, and it's just not as clear to us. So with apologies for that burden.
No, that's absolutely fine. I'm completely happy to work with the applicant to make sure that there's a comprehensive core document list that we can then number up for this particular inquiry, which possibly leads on to where you would like to have the deposit set, so that members of the public can come and see a physical set of documents when these are lodged. I do have one suggested venue. It does have slightly limited opening. The venue I'm suggesting is the Dornoch Service Point, and that's based in the Sheriff Courthouse, Castle Street in Dornoch. However, it is only open between 9 AM and 12:30 p.m. I understand it is open in the afternoon from 1:30 to 4 p.m, but that's just by appointment only. So that's probably one of the more local potential venues that hopefully would be accessible for all that want to see a physical set of documents.
Is it a local library, or is that in the same place?
The library is a possibility, and that is open as normal council library hours. Should you wish to go for the service point, we could perhaps work some arrangement with the community body to have it open in the afternoon, but I'd have to confirm that.
And the library sounds attractive because it's open longer. And is there space would there be space in there for the set of documents? And hopefully it wouldn't be too mammoth a set. But
Purely my judgment, but I think there will be space.
Okay, so just to clarify, yes, it's only that initial set of environmental information and application documents by the 21st of November, and the rest of the core documents they would come out through the later dates that we've talked about. So I'll come back to site inspections in a minute, but just continuing with documents. So we would encourage all parties to submit documents and preconditions electronically, so that they can be displayed on our website more easily for parties to view. And it's also helpful if lists of documents, inquiry statements, preconditions and draft conditions can be submitted as Word documents. So that they can be incorporated as appendices to our report, if appropriate. That aside, and as you've identified, we do need a hard copy of all the relevant material to be on display locally and on deposit. So that would need to include, and at the library, the planning application and the supporting documents, and we'll have that clarified by the date in November. All the representations to the planning application, and together with all the inquiry parties lodged by the main parties. And although we ask for the submission of documents electronically in Word, if possible, by preference, in order that the council can have one deposit version. In addition to that electronic exchange, our request is that one hard copy is also sent to the council of everything that you produce, so that they can incorporate that into the deposit version, that deposit set of documents, so that people locally have something in hard copy that they can go and look at if they want to. So the council's happy to coordinate that. One hard copy of everything would go to the council, and it would be at the Dornoch Library. And when the inquiry opens, the council will be able to bring those along, or by agreement, bring those all along for the inquiry for the start of the sessions. Okay, thank you very much. Site inspections. We already made a quick unaccompanied inspection of the links yesterday, and we'll be making more unaccompanied site inspections, I imagine. But either during the inquiry and hearing sessions, or perhaps more likely at the end of those, we'd intend to make an accompanied site inspection, which the parties will be able to attend, and we can discuss the arrangements for that during the course of the inquiry sessions. So I've already said that we'll issue the note of this meeting, and parties will have 14 days from that to confirm that it's accurate in terms of their intended participation. But before we go on to close the meeting, there were a couple of other matters that have been raised to us in correspondence over the last couple of days, and just wanted to mention them and see if there's anything further we need to hear about them at this stage before we go away and consider our position. So some of you will be aware that we received correspondence last Wednesday from Dr Dargy of Coul, and the letter asked us as reporters to request that SEPA participates in the pre-examination meeting and in the public inquiry itself. We invited SEPA to respond to the points he raised, and so we could consider the issue, and SEPA's response was copied into to some of those parties, and their view remains that they do not wish to participate, they don't feel the need to participate, and they referred back to their evidence in their various letters, consultation responses in support of that. So the request being made, a response has been made to that. I think it's for us to go away and consider that and come back with confirmation as to our position. But is there anything else that need to be said to us on that point before we do so?
I'm afraid there is. I appreciate I'm standing between you and your lunch, and I will endeavour to be brief. We regard this matter as rather important. Now, without rehearsing too much history, SEPA was originally an objector to this application in December 2017. In March, it withdrew its objection and said that it would be satisfied with the imposition of planning conditions. And it offered further advice informally. Last week, those instructing me wrote to you seeking clarification of 6 points in relation to SEPA's evidence. Now, it's quite apparent that you've read these already, so I won't rehearse them. However, SEPA's response of the 29th of October adds nothing to their letter of the 23rd of March this year. In other words, what they do is reiterate what they said, but in a slightly more condensed form. Now, I would like to make a formal application to you to, first of all, request SEPA to attend the public inquiry, and if they don't respond to a request, to ordain them under Section 235 to appear at the public inquiry session in relation to natural habitat. Now, it would take me 10 minutes to explain why I want you to do that, or I can do it in writing within 2 or 3 days, just as you prefer, because it is 10 to 1, and I understand that. Well, somebody's hungry anyway. You won't get fed in Clashmore, though. Broadly speaking, I'm sorry.
Yes, and we're worried that, not worried about missing lunch, worried about perhaps not properly recording your submission here in the forms of hurried notes. So if you want to make a further written submission quickly about it so that we've got time to consider and respond through the pre-examination meeting, then that seems the best option.
Right. I understand that, and I'll certainly do that by close of play next Monday, if that's suitable to you. I just wanted to make the formal application here, since we are in session, so that you have at least got a record of that, and it's not made in any mysterious way behind the scenes. I won't say anything about the merits of SEPA's response today, because, as you pointed out at the beginning, we're only talking about procedure today and not the merits of the thing. But what I envisage happening, if you're with me, is that SEPA would produce a witness to explain its response of 23rd March 2018, and also to explain the differences between its approach and that of Scottish natural heritage for the benefit of the inquiry. Thank you very much. Yeah, I'm sorry, I do have one other matter, which is not related to that.
Can I ask, I just want to ask the applicant if you've any comments to make on this matter.
Yes, just very shortly, the applicant's position can be stated. Any such application to ordain the attendance of SEPA will be opposed on the basis that it will take up unnecessarily inquiry time. SEPA is a very experienced regulator and consultee. Its views as to the way in which matters have been answered should be given weight, and this will just simply extend the inquiry without justification, so the applicant will oppose any such application.
I mean, that's fine. I mean, I think we can move on from that, but there was another point which has been raised about appropriate assessment of Ramsar sites, and which I was going to address. Is that the other point you were going to mention, Mr Campbell?
It isn't actually, because I think that's really a legal issue and it's not for today. I had thought that the absence of an appropriate assessment for the Ramsar site might be a legal showstopper, as it were, disabling us from proceeding, but I've changed my mind on that, and I'm going to leave it for the policy evidence which we bring forward. So the only matter I wanted to detain you with concerns the environmental statement and the additional material which has been lodged by the applicant. We have some reservations about the way in which that is laid out and presented. It's very hard to follow. I dare say, given what you said earlier to Mrs. Lyons, that's something that we can sort out and work out before we get to the inquiry. However, missing apparently from the hard copy material and the electronic copy material which we have and which is on the DPA website is the scoping request and the scoping opinion. Now, you may say that's not important now because we've moved forward, but to judge the adequacy of an environmental statement, you have to know what it was supposed to cover. And we have reservations about its adequacy. I don't wish to explore them today. In order to know what ought to be in there, I need to see the scoping opinion and scoping request. And in my submission, that should be a public document, which should be on the DPA website. So through you, I wonder if I might ask the applicant if that could be made available in a public way.
There needn't have been a scoping request and a scoping opinion. That's an elective part of the EIA process. Is that right?
Well, there may not have been.
Is that a formal request from the reporters to produce it, or an inquiry as to whether or not it can be produced? It can be produced.
Okay, thank you. Well, we'll consider that. I do want to come back to this issue of appropriate assessment, notwithstanding the points you made, Mr Campbell. So, for those who are not aware, RSPB Scotland raised the question of the need for an appropriate assessment. So that's an assessment of the type which is required for a Natura site under the habitat regulations. So the request was for a similar type of assessment of the impacts on the Dornoch Firth and Loch Fleet Ramsar site, and based upon the premise that these should have that it's government policy that these sites, Ramsar sites, are given the same level of protection as Natura sites. I suppose I'd like to ask SNH first. I mean, if you get any agree in that, and I guess would your evidence that you'll be submitting to the inquiry is that likely to allow such an assessment to be made?
So we have considered, but only in a preliminary sense, the submission by RSPB, and indeed there has been further correspondence between the applicant's solicitor and myself on this issue. We are not in a position to state our final position on this issue today. What we would suggest is that we fully consider the matter and set out our position in writing within, say, 21 days from today. I think it's in the interest of all parties that if there were to be a showstopper, as Mr Campbell put it, that the showstopper, the existence or otherwise of a showstopper, should be identified sooner rather than later. So,
when you say your position, do you expect further discussions between you and the applicant?
It would be in response to the material submitted by RSPB and the correspondence which we have had from the applicant's solicitors.
And does the applicant, I mean, obviously you've taken a view on this, and I don't know what that is that something that we should talk about just now so that I can understand where this is going?
Well, so the applicants have taken on board the advice that was contained within the assessment that the Planning Division produced prior to the decision to call in. And the premise that in order to afford Ramsar sites the same protection in Scotland as an SPA, that it's necessary to carry out an appropriate assessment in respect to the Ramsar site as opposed to an appropriate assessment in respect to the SPA. Generally, they're overlapping designations. There are a lot of nuances to that position based upon the facts of this case that differentiate it and justify a more refined, sophisticated approach to it than simply a general proposition that there has to be an appropriate assessment. Assessment is a technical term that relates to a Natura site. There's a separate question as to whether there needs to be an assessment that is appropriate to a Ramsar site, which is a subtle difference. And that's the matter that's being discussed internally within the applicant's team, and the intention is to discuss it with SNH.
And I'm nervous when I hear the word showstopper. If there was agreement on whether such a thing needed to be done and that it could be done, with the fact that it's not been done yet, why would that be a showstopper? Couldn't or that assessment then just be done and we could have it and move on? I don't see why it would be a showstopper.
So, if I could respond on behalf of the applicant, I've given this very careful consideration, and I don't consider it to be a showstopper in any shape or form. It's a matter that may require to be addressed. It's a matter that a position could be taken that there is misconceived thinking surrounding this, and therefore it's not per se required, but in the event that you would come to a different view, then how would you perhaps address that?
Okay. 21 days without being involved in the process sounds like a long time to resolve this issue when things are moving apace and we're asking for documentation to start to be submitted. Is that the best that can be done?
I would suggest so, given the different parties involved and given the complexities of the issues insofar as they relate to both facts and law and potentially policy. That's reasonable.
So that would be 21 days from today. That's the idea. Okay.
Not inviting a process, you're not envisaging a process where others, apart from the applicant and SNH, are involved.
I don't know what I'm envisaging at this stage. I mean, that's a discussion that's taking place separate to the inquiry, and it will resolve itself in 21 days, one way or the other. Maybe at that point, we need to think about the implications of whatever view comes out of that.
Well, I agree with my learned friend that this is a nuanced and quite difficult question. Whether it's a showstopper or not is probably not for today. But if SNH and the applicant reach an agreement on the law and the facts of this matter, the other participants in this examination will then have to decide whether they agree with the agreement or whether they don't. And if they don't, and I don't know which way that will go, but if they don't, then time to make their own submissions, differing from the agreement between the applicant and SNH. So whilst I have no issue with the 21 days, I would ask you, or ask the applicant again through you, the product of their discussions should be shared as promptly as possible, to save the waste of time which necessarily would occur if we have to, as it were, make our own submissions on this question.
You mean before we see them? You mean shared amongst the parties before?
I don't mind whether you see them or not, but it's always open to us to disagree with what the applicant and SNH conclude between themselves. But if we disagree, we obviously have to make a cogent case for you in that disagreement and not simply differ. But I don't want to take up the time of doing that or having to do it if in fact, we're agreed. So all I'm asking for is a rapid sharing of the product of their discussions.
Okay. I mean, my assumption is that whatever comes out of that process is something that we would have to see. We would have to take a view on what that was and whether there was a need for other parties to see. It would be what I imagine is the public as part of this inquiry, and therefore, whether invited or not, you could take a view on it and tell me your view on it. But I think at this stage, if we can just see where that takes us, and then if that's a submission that ends up being made between the applicant and SNH to us, then we'll need to take a view on where that takes us at that point. It's difficult to speculate beyond that just now.
So I should just make this point, which may allay to some extent my friend's concern, that the timescale that's being discussed would take us to the 21st of November. There's then 2 weeks between that date and the inquiry statements and the statement of agreed matters being involved. And I take my point to waste effort over his own. This microphone's coming and going. The case has been thinking about these issues over the past couple of months while this process has been ongoing before it came to you.
Okay, I mean, is that enough on that matter before we move on? Okay. I just had a couple of more wrapping up things to do, but is there anything else that of a procedural matter that we've not discussed that we need to discuss today?
Sir, just a point for your information to note. You may not be aware that the RSPB have corresponded with Scottish Government about calling in the planning application for the reservoir. I'm just mentioning that so you are aware. I don't think there's anything more that can be usefully said about that at the moment.
I was aware of that request. I mean, I'm not sure how I was aware of that, but yes, I was aware that request had been made, or that there had been correspondence about it. Okay, so we'll issue the note of the meeting. Fiona Manson is the PA case officer for this case, and so any correspondence should be with her. But our website will contain all the key documents in the case, and that should be the first point of contact, in terms of first point of call, in terms of to find out information about what's going on. So yes, so that reaches that's reached the end of the agenda. There's no other points parties wish to raise. It just remains to me for me to thank you all for your participation and to formally close the meeting. Thank you very much.